Alex here with a legal nuts and bolts video on putting the conclusions before the facts. The facts have to come first in any kind of analytical process. You look at the facts, you analyze them, and based on the facts, you come up with a conclusion. Now, things are more complicated than that, but for the purposes of this video, I'm just going to state that you need to make sure you analyze the facts and think objectively and come up with a conclusion from there. A lot of times people in high conflict child custody cases, and I know this is a legal nuts and bolts video, but this principle will help people in all types of court cases. In high conflict child custody cases, this is especially prominent. A parent will come up with their conclusion first, and the facts be damned. They'll figure them out later. And this leads to wrong-headed coordination, communication, um, jumping to conclusions that just aren't supported by anything, and it can make the parent look a little bit insecure and obsessive. A lot of times it manifests in a parent wanting sole custody or primary physical custody. That's their conclusion. Do the facts support it? Who knows? They just decided that's what they want. I want primary physical custody. That's my conclusion. So do the facts line up with that? Does the law support it? Who knows? It doesn't matter to me. I'm going to get a lawyer and I'm going to tell them I want this, and they're going to make it happen. And sometimes they'll have reasons that have nothing to do with the law or the kids. Their ex pissed them off. They cheated on him. They're just angry. They don't care. They want to get back at him. They feel like they deserve it. And so they have the conclusion. Well, the problem is when you're looking at your case in that way, when you've put the cart before the horse, you end up seeing everything as a reason why your conclusion is supported. Oh, look, they did this wrong. Oh, look, they did that wrong. Oh, look, they didn't do this. Oh, look, they didn't do that. And an ordinary person might see all those things as really petty and small. But to a person who's already come up with their conclusion, I want primary physical custody, those are like that. Those are the facts I've been looking for. I've got the facts now. I've been looking for you guys. I knew I was supposed to be entitled to what I wanted. I knew I was supposed to have primary physical custody, and I found all the facts that I wanted. They don't understand when they go into court they're going to look insane, or they're going to look dumb, or they're going to look petty, because those things don't actually support the conclusion that they want. The problem is you've got to prepare your head. You've got to think like a lawyer even though you're not a lawyer. You've got to step outside of your personal bubble. You've got to look at your case from the outside perspective. And part of that process is you look at the facts first. And you think about all of the facts, you consider them, and based on those facts, you formulate your conclusion. And that's the only way that you're going to have any kind of success in court, whether it's a child custody case or not. So I really wanted to just put this video out there for people who may have gone through this in the past, who may have wanted a certain conclusion so badly that they allowed themselves to believe that any little fact that supported it would basically justify it, and it's just not the case. Cases are so complex. Cases are multidimensional. You have to look at not just your facts, but your opponent's facts, assertions, allegations. You just have to look at all of the facts, allegations, and assertions before you render any conclusions. And if you do things in that way, you're going to be a lot more likely to come closer to a possible court outcome than if you make a list of what you expect to get now and try to piece together all the facts later. It's not a good idea. It's not a good way of thinking. The court process, the judge's way of thinking, it's not conducive to, or those methods and that backwards way of thinking is not conducive to how the judges think and how the case is going to go and all of that. So I wanted to add one extra little bit before I stop this video is putting the conclusions before the facts may not be good, but it's okay to put the conclusion and the facts before the evidence, because sometimes you'll have figured something out and you just won't have the evidence yet. That is okay to do. Hunting down evidence is different. If you've seen the signs that support a certain conclusion and you just need to go about gathering the evidence, that's more of the hard work part of the process. So for example, my son's teeth were rotting, and I needed to get primary physical custody because his teeth were rotting and my ex wouldn't brush him. So I had the facts, I could see what was going on. I had the conclusion. I knew what I needed to get from the court system. I just had to go about getting the evidence. And that's where I was like, okay, let's do some research. I need red coat tests. I need to take the tests at least this many times. I need to do it after I pick him up so she doesn't say that his teeth were rotting during my time. I need to have the dentist do it at least once, maybe the hygienist do it a couple of times, so that way I have some witnesses. So yeah, getting the evidence can come later. That's fine. It's hard work. It's, you know, you got to put the elbow grease in to get into that part of the process. But it's okay to work out what's going on, get your conclusion, and then figure out how you're going to gather the evidence whenever you can. Just wanted to clarify that point before I ended this video, and with that, I will see you guys next time.